All right, Mike, you ready?
I'm not sure.
All right, Mike. Well, I don't know if anyone's ready, but we're going to give it a shot, right?
Why not?
Go
So
for it.
today is July 31st, 2024. We've already seen in our market that in, what was it, Marco, they have restricted any viewing of any sort of commission splits on their MLS feeds. So if you're curious how this is going to look, you can look at how Marco Island is doing it, and I believe Naples is moving into that tonight. So everyone will most likely in our area will see this impact listings across the market as early as tonight. And, there are a lot of feeds to that. Technically, the NAR settlement compliance doesn't start until August 17th. So we can, this is almost like a little bit of a trial period, but it has real consequences if we're not careful. So, Mike, can you start us off? You talked to me earlier. You said you've got your phone is basically burning a hole in your ear. Tell me kind of the feedback, what people want, and what you're telling them.
All right, a couple important points. First off, a lot of agents' questions can be answered by going to the NAR site to look at their Q&A. A lot of those scenarios are there, but not all of them. And the reality is that with some of the questions, good questions that agents are coming up with, some of those questions will take a while to answer. It's sort of like being on uncharted waters. So we will get you the best info that we can. But one of the questions that agents ask, and I'm getting this over and over and over, is how do I explain this to my buyer? How do I explain this to my seller about why, what is happening and what it means to them? NAR came out today. Look for an email. If you're a real estate agent, look for an email from Katie Johnson from NAR. They have two handouts. The first one says, home sellers, here's what the NAR settlement means for you. Looks something like that. And then they have the same one for a different one for home buyers. So if you want a short little handout that you can hand to your buyer or seller explaining what's going on, it's short, it's sweet, it's got 5 or 6 bullet points on it. And the email just went out today from NAR. I opened it, read it, and I went, God, this is kind of what a lot of agents are looking for. So that's how you possibly explain it. Now, I'm getting some of the same questions over and over. What is the impact with the buyer broker agreement if the compensation in the buyer broker agreement is below what the seller is offering? Well, obviously you can't pay more than what's in the buyer broker agreement, but you do have, and Christian, correct me if I'm wrong, there is a form that could amend that. Now, the buyer might say, I don't want to amend it. I want to stick with what's in the buyer broker agreement. Fine. They could say anything. They might say, yeah, I'm fine with that. Where do I sign? You don't know, but there is a document that can amend that buyer broker agreement. But here's a real important point. It's got to be properly signed and dated by the parties that were originally part of that buyer broker agreement.
Yeah.
So, if you don't have it dated, or maybe it's Christian, what's the ramifications of that if the buyers are a husband and wife and only one signs the buyer broker agreement? That's kind of an interesting one.
Yeah, it's a good question. So what I'm telling people is try not to overthink it. Like you said, some of this is uncharted territory, but the NAR settlement wasn't written to anticipate things like, well, what if the husband signs the buyer brokerage agreement and then they go under contract as husband and wife, or what you saw yesterday, Mike, which was the trustee signs the agreement and then they open up a new trust for the actual closing. Is that a problem? Again, I would go talk with your broker and make sure that if that scenario happens, that you're still okay. but legally, from my opinion, that's going to be okay. You know, the contracts are assignable, things like that are going to happen. It's all about intent. You know, were you working with that person, that party, that member, that group, and now that group, no matter what the entity is the one buying. Can you show a connection? Is it
Well,
that?
the other interesting thing, Christian, is with some of these questions, when you attempt to get an answer, you're going to get a wide variety of answers to the same question.
Yeah.
So
Yeah.
we're all trying to figure it out. What's going to happen is over the coming weeks and months, best practices will be developed. Yeah, we will figure it out. We always do. And we will, and yeah, but give the broker, I'm not speaking for my behalf, but you know, whoever people work under, give them a little bit of time to get the answer, because some of these answers, you got to make multiple phone calls, and if you call two different law firms, you might get two different answers. You know,
Yeah.
this
Yeah.
is new for a lot of us.
Look at my new feature, Mike. See this?
Look at that. Nice, nice.
So this is the amendment to the buyer brokerage agreement. NAR or NABOR has one, and I think all the other forms have one as well. They work, right? There's nothing in the settlement that prohibits their use. Just make sure that the original buyer brokerage agreement is signed before you start showing properties. And then if you need to amend it or can amend it later, that you do that. That's all we can do at this point.
There's a lot swirling around right now. And Christian, you pointed out that Marcos deleted their compensation fields yesterday. That's correct. Neighbor and Bear will do it tonight, and Royal Palm. You're right. We have a grace period, you know, from August 1 till August 17th. Technically, that agreement doesn't kick in to August 17th, but this gives us a great time to practice
Yeah.
and try to get this thing right.
Yeah, so Mike, one of the first questions that Bridget had, the buyer brokerage agreement, how do we use it? Which we've kind of addressed. And should we be using that form? Yes, we should be using that form. The NAR settlement will require it no later than August 17th. But because the MLS is changing what they show now, you got to get that buyer brokerage agreement now, because that is your saving grace. That is the thing that protects you in the event the listing agent or the seller refuses to pay your commission. And it's good because we're only, we're a little more than 2 weeks away anyways of being required to use that form. So yes, use it, start working through your pitch, how you present it, how, kind of fielding questions and concerns from buyers. And that way, by the time you need to use it, you've already got some comfort with it.
Well, and the other thing I would point out, if you're representing a buyer, I certainly would let the buyer know that all realtors are going to have to use it. It's not like they don't want to sign it with you. They'll use this guy down the street who's not presenting one to them. Yeah, he could get in a world of trouble if he does that. So if they know that everyone has to do it, I think that might be very helpful.
Look, as I'm playing with all my tools today. All right, so we got another question. Lisa asked a great question. She wants to look at number 9. So this is the new NABOR buyer brokerage agreement. You can tell it's the new one because it's highlighted. It says July 12th, 2024. So the prior buyer brokerage agreement was updated in 22. She wants to look at number 9. And her question is, why did they even include this stuff? Buyer, this last line here, buyer elects or declines to be shown properties where no seller concession is being offered in connection with the sale thereof. Why did they even include that? I don't know. I think, so I was talking with some of the members that are on this forms committee this morning, and, unfortunately, they can't change the forms and recreate the industry in a 3-month period. It's just not terribly realistic. So what we focused on was bringing the forms into compliance with the NAR settlement. And that's a pretty low bar, but it was still a ton of work. Just to get you into compliance with the NAR settlement, that was step 1. fast forward, we still have a whole rest of the year. They're going to be modifying the sales contract, and they might be changing all the contracts again, maybe a second change in 1 year. And so that's where I would wait for that. But this language here was in an attempt to comply with the NAR settlement. Dad, have you heard anything about that?
I haven't heard a word about that. I know it's in there. I know that the seller can offer buyer concession. Why they put it in form, I have no clue.
Yeah, I agree. It's hard to tell. It was, the forums committee was tough. They were asked to do a ton this year, and this is just their first bite of the apple to make sure that we're in compliance. So we talk about this buyer brokerage agreement. Generally what people tend to argue with on it is the term of the agreement. So number 4, that's the first thing that people point to. What should we put? Honestly, I would look at it similarly to a listing agreement. If you can get a 12-month term, I think that's a great deal. Do 12. If you have to do 6 months, ultimately this is a business decision. If you only get 30 days with this buyer, maybe it's not worth it. Maybe you need to charge more given the less time period. I don't know. Maybe you need a retainer fee if they want to limit the amount of time that they're bound to you. I think that's where your push and pull, and that's where your business acumen will pay off the most. And then, so what you would put is ultimately what you're charging to help these people find a house. And then they have the same thing for rentals. Scope, number 6. This is a new field as well. The agreement is only applicable to residential property located in the following counties in Florida, if blank, then Collier, Lee, and Charlotte. I don't know why they did this with NAR. I wish it was just like the default was all counties in Florida. I think that would have been better. So I would, if I were you, I'd put in all Florida counties. That's probably what I would do, because I don't really want to be limited to these 3 counties. What if my buyer goes over to the Keys and wants me to get paid? Okay, let's do that.
Christian, you hit an interesting point there. We have a lot of agents now in our area that work both coasts.
Totally.
So, where's that leave you if they work Miami or Lauderdale? Because we have a lot of that.
Right. So that's a big one. Number 7 is the default. Now, Dad, you and I have talked the last couple of days about what are called no-hook buyer brokerage agreements. We're trying to get up to speed on what that even means. It's a new term that came up. Dad, what is your opinion? How did you define what a no-hook agreement is?
It's a unilateral agreement, which is basically no agreement. The buyer has the option of paying, but not the obligation of paying. He evaluates the quality of the work of the selling agent through the course of the process. And if it's a person who just took a nap or didn't respond to phone calls, didn't show the property, did a terrible job, the buyer would have the option of paying less or nothing.
Yeah, basically the buyer is not obligated to pay you if they fire you, essentially.
Right.
That would be what's called a no-hook agreement. And that's what a lot of agents are asking for, and it is not what this form is. This form would be a typical exclusive buyer brokerage agreement, which says, if I find you a property, you have to pay me a certain amount, or we have to build it into our purchase with the seller paying it or the listing agent paying it. But the buyer is ultimately obligated to it. So at some point you may hear about a no-hook agreement, and just know that's not what this is. And there are downsides to a no-hook agreement. No-hook agreements, a buyer could fire you. A buyer could weasel out of paying you commission. So there's a reason why NAR did basically an exclusive buyer brokerage agreement as its replacement. But we'll see where the industry, where the public wants us to go, and you'll have options like no-hook agreements in the future. But this one basically says, if they don't pay you, if they try and cut you out of the deal, you can come after them for damages, which would be how much you're owed. It even allows you to put a lien on the property. So which lien can be foreclosed in the same manner as a mortgage or security instrument placed upon said real property, and which lien shall survive termination of this agreement. I am hearing a lot of, ultimately reason why a lot of buyers refuse to sign these, or at least our interpretation of it, is because of this lien obligation. Lien obligations are actually pretty valuable because if you have a buyer who goes and buys a homesteaded property, you can't put a lien on it unless this language applies.
Right.
So you kind of have to. A buyer could totally cut you out of the deal, and if you don't have lien rights, you're totally cut out. Good luck. So I think you need the lien rights. There's a reason why it's in there. And if a buyer were to fight that and like, oh my gosh, I don't want the lien, you're gonna have to talk to your broker, talk to an attorney, and think about whether you want to take that language out. Typically, Dad, we would see in contracts some sort of like, non-exclusive. You could basically any damages in law or in equity. But this one actually goes a step further to protect the realtors. So keep that in mind. This is a big thing that protects the realtors.
Christian, the only time I've ever had problems with this lien language is when the listing agreement was being reviewed by an out-of-state attorney, and it X everything out in the default clause. And but typically people don't read the entire document, and they miss it. So in my conversations with out-of-state attorneys, we try to leave enough in the default clause so that we have mutuality of obligation between the parties, that there's some sort of penalty.
Yeah, yeah.
And that the agent agrees with it.
Well, and so you keep in mind, everybody, you've got two things going on. Attorneys are always going to look to, is it a valid contract that you can enforce against your customer? And then separately, are we in compliance with NAR? You could have a non-enforceable contract, but be in compliance with NAR. Maybe that's your plan. Maybe you're like, look, I don't want to force my buyer to pay me this. I'd rather give them the out, even if it's a voidable contract, as long as I'm complying with NAR, as long as my broker still pays me my commission, I'll take that gamble. There's a, Dad, you and I really love The Profit. Remember that show?
I love that show.
So it's on MSNBC. It's hosted by Marcus Lemonis. And one thing that I always thought was really, really interesting was that when he makes a deal, so he goes around the country, he buys pieces of small businesses, and then they shake on it. So they'll be like, Mike, I want to buy 20% of your company for $100,000. And they shake on it. They do not sign anything because he said, if you're going to take advantage of me, if you're going to be a disaster, you'll show your true colors a little sooner if there's no actual contract.
Right.
So there's some legitimacy of like, that could be your business strategy of having a no-hook agreement that the buyer could ultimately get out of, as long as you've kind of calculated the downsides of that. But that
Christian,
tends to be a big issue. Yeah, Dad.
what do you think of using the no hook and then using the amendment to turn into a hook after you've shown the property or done some negotiation?
That's pretty cool. I like that. I haven't thought about that.
I mean, it'd be a real easy way to show property. Sign this, you don't have to pay me a darn thing. Let's go look at the property. They don't even know the agent at this point. So you're trying to develop that relationship, the trust. And once they're ready to submit an offer, then you go to the hook or the obligatory payment to the selling agent.
Right, right. The last thing I would point on this is I actually thought it was interesting. B, so this is 12B, buyers shall not have the right to assign this agreement without the broker's written consent, and buyers shall not be released from liability under the agreement. I'm not exactly sure why NAR wrote it that way. I think it should be assignable. Ultimately, Mike and I talked about this yesterday, and we were like, well, given that issue that we were dealing with, maybe you put Donald Ross and assignees. And that way, if Don adds his wife, if he puts it into his trust, if he opens up an LLC, it's assignable to those and fully committed to that. And it would override 12B in a most likely case.
I disagree with that, Christian.
Okay.
If the obligor has the right to assign his obligation to anyone he wants, he could assign it to a newly formed LLC that has zero assets. So
well, it still says buyers shall not be released from liability.
Missed that.
So that could say, that's how NAR has it in our sales contract. So maybe that's our solution. So, you know, these are issues that NABOR was not really prepared to address until they happened. Probably not enough time to go through that. Mike, initial thoughts on things like that?
Yeah, no, it's actually kind of interesting. I mean, when you start talking about something, I think of three other questions that pop up,
No, it's
just,
scary. Yeah, it's a pain. So we've talked about, you know, yes, you will need a buyer brokerage agreement no later than August 17th, but I would suggest getting them started now. The next step is a commission agreement, or what they call it, a compensation agreement. Let me show you what that looks like, if I can get there. I just like all these toys. All right, so this is a broker compensation agreement. This one, listing broker has entered into a listing contract. They've agreed to pay the buyer's broker a certain amount of compensation to the buyer's agent. This would be included in the offer. So you have a buyer brokerage agreement, you still need that. And then when you make your offer, you would include this compensation agreement with it, which obligates the listing broker to pay your commission.
Would you make it an addendum, Christian?
Say that again?
Would you make it an addendum like the FAR form we went over before?
Yeah, I would. Although if you didn't, as long as it was signed by the broker, you're probably okay. But, you know, if the seller is paying it, you know, we talked about this in a prior video. If you haven't seen our prior videos, you can go on YouTube and find them. It's youtube.com/Christian Ross. So if you know, we like this being an addendum to the sales contract. Check the box, the other box, and put in compensation agreement. Definitely our preference. But if you didn't have that, you better still make sure it's signed and part of your offer. Dad, the other option, I guess, was, you know, writing in other terms and conditions that listing broker shall pay. That's problematic because the listing broker doesn't sign the sales contract.
That is true.
The best you could do, if you were going to put language in and not use this form, the best you could do is to say seller shall pay, you know, whatever broker a percentage, you know, whatever your amount is. Now, here's the key. And Mike, I know you've gotten this question. So you've agreed on a buyer brokerage agreement to earn, you know, a certain amount, but the listing agent tells you, hey, we'll actually pay more. What can you do? What are your options in that scenario?
I know what I'd say, but I'll defer to the attorney on this one.
Yeah, so it's
And
tough.
I've had this question at least 20 times.
Yeah, so this is the question. You agreed to 2%. The listing agent says, I'll give you 3. Can your, and maybe even they sign a broker compensation agreement saying 3. Can you take advantage of that extra percent, that extra money on the table? Well, you can, but only if you amend your buyer brokerage agreement. So you've already got a buyer brokerage agreement. It says 2. And then the listing agent says, hey, we'll offer you 3. They sign the broker compensation agreement. You've got to go back to your buyer and amend the buyer brokerage agreement that you'll be able to accept more. And if you can do that, I think that's great. Double check with your broker that they'll allow that they'll pay out the difference. But if the buyer says no, or if the broker says, hey, we can't allow you to accept the extra, then that money doesn't go to you. It goes back to the listing broker.
If I were the buyer, I'd want half of that 1%. Why should I?
Yeah, I mean, ultimately this lawsuit and the reason for the settlement was that, you know, we want full transparency. We want the buyer and seller to have the ability to negotiate. We want it clear that commissions are negotiable. And so that's why they force you to go back to the buyer to amend that agreement. And if they don't agree, if they look at it and say, well, you know, that should go to mine, that's my money, you're gonna have to negotiate with them. Maybe you split it with them.
If I were the selling agent, I would make it clear to the buyer that this is my way of compensating you for some of the repair items that invariably the selling agent has to credit the buyer some portion of the commission for. So maybe they can transform that into a credit for repairs for the new hot water heater, the new air conditioner, whatever it might be. So
Yeah, that's
don't
great.
get
It's a business decision. I personally, I like the idea of saying, hey, you and I agreed on a certain amount and I'm not going to change it, right? I'm not going to come down and I'm not going to go up. Anything that I negotiate for you above and beyond what I'm owed, that goes back to you. And I think that is, that would be a business decision, because alternatively, you're looking at it on a deal by deal basis.
yeah.
It's
just want to be double dinged. You don't want to be hit for a repair credit and this part of this.
Yeah, yeah. And if you're gonna give that up to a buyer, then like you said, Dad, make sure they don't come to you later for, giving a little money to get over the finish line, because that happens a lot. The
Yeah.
realtors are there. People are always putting their hands in your pockets. We got to avoid that as at all costs.
One bite of the apple, that's it.
Yeah, exactly. Don't keep coming back to me. This is one and done. All right, let's see. Mackenzie had an awesome question, and I don't know if Mackenzie will allow me to let her talk, but we're gonna try because she's a pretty smart girl. Let's see what she says. Where are you, Mackenzie? I gotta find you. I'm warning her. All right, so you just have to unmute yourself, Mackenzie.
As
There
long as
she
there's
is.
no camera, we're
No
good.
cameras, just your voice.
Hello, everyone. I had a few questions. Which one do you want me to do first? The first
Whatever
one?
you want. Start with
Good
that,
one.
the timelines. I thought that was interesting.
So I've gotten conflicting answers from different attorneys. So, NAR is putting out the timeline of buyer broker agreements needed to be enforced by the 17th, but Stellar MLS, for example, is requiring it by the 6th. So which do we follow?
So I think that you got to follow the one that is the most restrictive, because nationally it is the 17th, but if you're subject to a local board or a local MLS that is requiring it sooner, do the sooner.
Okay. Okay, and then my other question was, I know, every area has their own set of forms, right? NABOR versus FARBAR.
Yeah.
NAR introduced a pre-property tour agreement, right? Because to everyone's point, who's going to want to sign a hook contract for example, with an agent they've never worked with before? So
Okay.
that pre-property tour agreement to kind of show our value the first day. I know someone brought that up to Pat, and Pat said we're not using it because it's FARBAR, but we have FARBAR forms. So is Downing Frye just not allowing us to use this, or just a little further explanation on that?
I think Pat has a preference, but I'm not going to say that we won't allow it. I would, and there'll be more conversation on this in the coming weeks. The reason why certain forms seem to be better than others. But if it's a FARBAR form, it's been released. Certainly, I'd be very surprised if we didn't allow that.
All
I
right,
think
so Mackenzie's got, this is a good form that I honestly haven't spent a ton of time on before. This is the property pre-touring agreement. So this is a FAR form. It is not FARBAR. And it basically says, you do not owe broker any compensation at this time. If you wish to work with the broker to purchase a property, broker's compensation for services will be as follows. Buyer broker may ask you to sign a separate agreement detailing the parties' responsibilities during a sale. A seller or listing broker may agree to pay some or above of the compensation. This is a no-hook property agreement, buyer broker agreement. And so the real question, Mackenzie, is will your broker allow you to use this in replace of an exclusive buyer brokerage agreement? That is the interesting part. Does this go far enough to match the requirements of the NAR settlement for you to get paid at closing? Or will they make you then sign an exclusive buyer brokerage agreement at that time, before you make an offer or something like that? The reality is policing the NAR settlement is going to be very hard to do. We're not going to know when you started working with a buyer. It's going to be very hard to determine that. So I love this. It's really good. You don't have to use it. I think if you really want to simplify your strategy, just get comfortable using the buyer brokerage agreement. This
I
is
just thought
a
that this was
crutch.
for a buyer who refused to sign a buyer broker agreement. This is kind of a last resort.
So if they refuse to sign a buyer brokerage agreement, you have to realize that they may refuse it when you actually go to make an offer as well, right? They could try and cut you out of the deal. They could do, they could do any number of things. That's risky, right? Now, maybe you decide not to waste your weekend working with this buyer.
Right.
Because ultimately, based on your broker, you're going to have to know, is this enough?
If you think about it, Christian, not every buyer is going to sign that agreement, just like right now. If you meet a prospective buyer, not every buyer is going to go with you. They might go with the guy down the street. So this is a way of kind of each party agreeing whether or not they're going to work with each other. And then, do you want to spend a lot of time, as Christian just said, working with someone if they have absolutely no intention of using you and signing anything? I mean, this is a way, in effect, I guess, flushing them out on do we have a working relationship moving forward?
Mackenzie, just to close up the loop there, I think Downing Fry is going to have to get back to you on whether this is enough. That's the real question.
And here's a question for you, Christian. If you use the exclusive buyer broker agreement and put down 0 as compensation, what's the difference? You amend it later.
I love that. Right. So what he's saying is that you just say, all right, we'll just put 0 in the amount, in our compensation amount.
Yeah.
And then we'll do a broker amendment or a buyer broker amendment when we find out what the seller's agent is offering.
You turned it into a no hook.
That
Yeah, I like
turns
that
it
a lot
into a
better.
no hook.
Can I ask one more question?
Oh,
I'm sure it's a stupid question, but I'm sure someone else is
I
thinking,
doubt
so
it.
I'll be
Go
the
for
brave
it.
one to ask.
Nobody's gonna call us.
So with the NAR having their own buyer broker agreement and then FARBAR having their own set, is there any issues if we have a FARBAR buyer broker agreement in place, but then the offer's written on a NAR contract?
No,
Okay.
no issue whatsoever.
You know,
And it's a preference thing. Your broker is going to have a preference. Hey, we just like seeing this on the same. And so it might throw a broker a little bit, but at the end of the day, contractually and per the NAR settlement, you can mix and match those. You could have a FAR listing agreement, a NABOR buyer brokerage agreement, and a FARBAR sales contract, and a FAR seller disclosure. Just make sure you know what you're doing. But yes, you can do that. Go ahead,
Okay.
Mike.
following up on Don's point about putting the 0 in there, initially I kind of liked that as a solution, but then if you have an unscrupulous buyer, and let's say the seller is willing to offer X%, and your buyer says, now that he's locked into a contract, says, no, I kind of like the buyer broker agreement that says 0. I'd like to stick with that. Where's that leave you?
With 0.
Yeah.
Yeah, it's a problem.
That's the downside.
That's where it's like, if you're over concerned with the buyer giving you a hard time and you think it's going to be impossible to get them to sign this, the downside of continuing to work with them is that they might take advantage of you. It's that Marcus Lemonis thing again, where I'd like to know that you're going to take advantage of me up front and just refuse and be a jerk about signing the buyer brokerage agreement. And that way I have more information about, is this really who I want to work with? Are they going to pay me or not? I'll give you a scenario. Here's a scenario. Dad, you may have heard about this one. This is an agent that we adore. Really, really good, goes over and above and makes all other realtors in this country look great. Because he's great. He is awesome.
Right.
Well, he has a client who is selling his place. He's going to be the listing agent, so they're talking. They're kind of thinking about what to do, and the client says, "Well, I'm thinking of upgrading, and do you know anything that's coming on the market? I don't really see anything that I like." And he goes, "Well, I think this property down the street will be coming on the market at some point this year. It's not listed yet, but I think it's going to happen." Well, guess what the buyer does? He goes and knocks on their door and makes a deal with the listing agent. It was coming on board like a week later. And so they go make a deal without our agent involved.
Right.
And then they come to a number, they come back to the agent and say, hey, you know, we got the deal. He goes, what are you talking about? He goes, well, I went and knocked on their door and we made a deal. And he's like, okay, well, let me reach out. And he said, well, no, you're not involved. You're not part of the deal, but we'd love for you to help us write the contract. And he says, because he's a good guy and he wants to do the right thing, he says, okay. And it's a customer of his because they're doing a listing anyways. He's like, all right, I'll write up the contract for you. We'll put it together. What's the purchase price? $3 million. Oh, okay. And he's like, well, you know, I'll pay, don't worry, I'll pay you, you know, a fair rate. And he's like, you just let me know what it is. And he's like, well, it's just to draft the contract, right? He says, yeah. So he drafts the contract. He says he's going to charge him $1,500, which honestly is really low. And then he gets dragged in for inspections, for writing up the buyer election, seller response, and honestly, the price wasn't firm yet either. So they were negotiating. I think the realtor spent, I don't know, 3-4 weeks of his life getting a call 3 or 4 times a day from this buyer. And he did it all for $1,500 when he normally would have made, you know, 2%, 2.5%, 3% on a $3 million property. And he told me at the end, he goes, this was a lesson learned. And here was the lesson. Number one, if you're good at something, don't do it for free. That's a big one. And number two, determine if you can do it without being all the way in. This realtor couldn't. He doesn't know how to do it halfway. He doesn't know how to just do the contract and then back off. Maybe you can. He couldn't. He failed. He failed spectacularly. And I can't replace the job that you guys do either. I'm not that available. You know, we're going to do 100 deals in a month, and I can't spend 3 hours on the phone with every buyer and every seller. I'd be in the office. It'd have to be clones of us. That just doesn't work. Dad, were there any other lessons you learned from that?
Two thoughts, and this goes back to lawyers being sued. Actually, you need something in writing outlining the scope of your responsibilities. Otherwise, the inference is going to be that you're in for the whole thing. And just because you're preparing the offer and between you and the buyer, you're saying it's just for the offer. Well, if it gets to trial, that his story is going to change. So you need something in writing saying, all I'm doing is doing this offer gratis, and that's it, and I'm out. Alternatively, you can have a retainer and an hourly fee. So if it gets into quicksand, you know, unforeseen, you know, the seller on the other side is really, really difficult. You know, you have a record of what you're owed. Now, the question is, what's your hourly rate? I mean, nobody's talked about that.
Yeah.
You know, Christian, we had a real example of this years ago, and I'm not sure if Don remembers it. It was down on Marco Island, where both parties contacted one of our agents, wanted him just to write up the deal, just to write up the deal. Remember those words.
Right.
Well, both parties were doing a bad deal, fraudulent deal, but they didn't tell the agent that. They left all that stuff out.
Oh, I remember that.
Literally, the agent charged $100 to write up the deal, and then spent a lot of time with the authorities explaining. You know, if you're just writing up the deal, how do you know they're telling you everything? So there's a lot of risk, and I tell agents over and over, I'm not a big fan of just writing up a deal.
I'm really not either.
I've done this, Christian. I mean, I wrote up an offer for somebody for gratis. It was for a lady whose husband was dying. She gave me the information. I felt sorry for her. I filled it out. I asked her if she was in an HOA. I got an email saying no. She submitted the offer. It was accepted. Guess what? It was in Pelican Bay. So we didn't have the HOA addendum to the contract. The buyer went to another attorney. They canceled the contract because they lacked the HOA. And the seller turned around and sued me. I did it for free. All I was doing is filling out the contract. I had an email saying, we're not in an HOA. And the insurance company settled for the cost of litigation. It was $40,000. That's what it would cost to prove that I was innocent. I mean, I had it in my file that I did nothing wrong. So this very easily can happen to any realtor who just fills out a contract, is my point. And
This
they're done.
falls
yeah.
under the category, what can go wrong? A lot.
It's money. They
We
say,
get
not-
asked that question all the time, Dad. You know, we are asked all the time, hey, you know, actually, this was really interesting. About a month ago, someone reached out and said, hey, what would you charge just to do the deed? You know, just to, you know, draft the warranty deed. I can do everything else. I
yeah.
said, well, I don't do it that way. He goes, well, I just, you know, what do you charge? I'm like, well, we charge X. He goes, what? He goes, I just want you to write the deed. I said, we're not built that way. We can't be just 1 foot in and 1 foot out. It's like we're either all the way in or we're all the way out. And, you know, if the market changes and that we can no longer sustain a business with that mentality, then so be it, we'll change. And maybe you'll change as well. I wouldn't start with that. I think you gotta decide, what is my business going to look like? Am I going to do a bunch of, you know, $5,000 deals? Well, you're gonna do like a half a dozen of those every month just to like keep things running at the same pace. You know, that's really, really hard. It's hard to get one deal. So I'd almost rather focus on the buyers and the clients that are going to work with you all in and see if we can make that work.
And
Yeah.
unless you've been sued, and I'll just say this: lawyers and realtors make lousy defendants. They don't generate a lot
Because
of.
juries don't like us. Yeah.
They don't like me. They don't, you know. Again, my father was a realtor. We would joke about this. You know, you do not want to be a lawyer defendant or an attorney defendant. You know, you're not likable. You're going to have some little old lady as a plaintiff, and you're going to get nailed.
Someone asked about new construction contracts. We've actually talked a lot about those, you know, with specifically if there are bonuses or excess commissions. You know, the simple answer is you're going to have to amend your buyer brokerage agreement, or you're going to be leaving that money on the table or giving it to the buyer of some sort. So we've actually done a lot of videos on that. If you check out youtube.com/Christian Ross, we put all these videos on there. You know, someone else asked, are we going to go over the different buyer brokerage agreements? Not in this video. You know, at the end of the day, I'm not going to focus too much on what the buyer brokerage agreements say, other than you get them filled out and you sign them. That's the key. You know, if you have a buyer that's going to modify them or change them, or if you want to, you know, get your feet wet and try and understand them, you got to start with them first. And then if you have specific questions, call us. We'll do videos in the future going over each form, or we'll write some articles about it. But get to know one form, get it down pat, and then refine your pitch. Refine your pitch. Can the difference be offered to the buyer? Yes. The difference, so if you agreed to 2, the seller's offering 3, and you can work that into the deal as a credit back to the buyer or as a lower purchase price, you should do that. In fact, if the listing agent gives you that information, you now know how to negotiate. You know there's 1% there that you should be able to get back. You should either be able to offer less amount, or you should be able to get that as a credit. Coco asked, what about if you put in the compensation agreement 3% or any amount greater if seller offers that? May we do that? No, you cannot do that. It has to be specific and it can't be vague in any way. The most vague is that it's a percentage of the purchase price. So it's already kind of vague. Now, Dad, you and I talked about a term that you and I never really knew about, commercial blackmailing. This was a really interesting, you did a good job of explaining it. Do you mind kind of telling people what that meant?
That's where you know, you make your offer. It's subject to the seller paying the selling realtor 3%. Listing agent calls the selling agent and says, we'll do that if you offer more. It's a kickback.
Yeah, so they basically say, we'll agree to your price, but you've got to, or we'll agree to your commission, but only if the price is 3% higher.
You know, we ran across that in a blog, and it's litigated in different fields. It's a federal issue.
Yeah, it's a good reminder. Let's not get too cute about this. You know, it's transparency, openness. You know, if the listing agent were to call you and tell you something like that, immediately tell your buyer and put it in writing. Hey, by the way, we were told this. Let's keep negotiating. Let's keep doing this. You know, we have a little more information. But if you kept that to yourself and steered your buyer in that direction, you could open yourself up to a lot of problems. But the big lesson is you have that buyer brokerage agreement signed in advance by your buyer, a specific amount that you're being paid, a percentage or a flat dollar amount. That's how it needs to be. David asks, how can we get the broker to sign the broker compensation agreement in a timely manner, or will agents be authorized signers? Mike, what is your company doing?
Read our newsletter today for the Downing Fry agents, because in it, you will find out you will have the ability to sign it unless there's something under other terms and conditions, and then that you got to review with the broker before it gets signed.
Yeah, this is a big step for the industry. And so Downing Fry is trying to be proactive in saying, you know, if we trust the forms, we're going to trust our agents to fill them out, and they have our authorization to sign them. I think it's a huge step. If you're going to make an offer on a Saturday night and go see a property, you're going to be allowed to sign it as long as it's super clean, you know, or you're just filling in blanks. We don't want a modified contract. We don't want any sort of weirdness. Just, you know, you have their authorization, and then send it for review as soon as you have it, and put it in front of people. But that's good. That's a huge benefit to you guys, and it will kind of alleviate some of those bottlenecks, I hope. Vicky also asked, can we mix forms NABOR and FAR in the same sale? Potentially. We did talk about that. You know, the one question that you have to answer is, does the NABOR form contradict with the FAR form that you're also including? Or do they reference the wrong line numbers or the wrong defined term? That's where, Dad, you and I always freak out about it, is
The terms.
the term. So generally you could write a contract on a napkin. That's fine. But you just don't want to say, well, this reference to something that doesn't exist. That would be a bad no-no. Jim asks, why would consumers or buyers not make an end run around the buyer broker and go straight to the seller in Zillow, Realtor.com, etc., and get out of paying a buyer's commission? They probably will. They'll try to, unless you establish your relationship and your value. That's the only solution. You have to bring value to the transaction, and people will pay you for it. If you stop creating value, you will not get paid for it. If you do these workarounds, if you're weak in a way of, like, let's say a customer doesn't, refuses, the word we heard earlier is they refuse to sign a buyer brokerage agreement, then they're probably going to work around you. That's not a great customer. So if you give them a way to go around and you're not creating value, then they will do that. It's, they'll find the lowest hanging fruit. And, I'm subject to that too. I'm only human. If I find a deal direct, if I'm working with an agent and we don't have anything signed, and then I find a deal direct, I find it, I work it, I'm not going to want to pay an extra 3%. That's a big number. And it's like, I did all the work, and what the heck? Don't give them that opportunity.
If you actually get a heads up on this, I mean, I would be pointing out whether or not that listing agent farms that community, because that shows a direct conflict of interest. I mean, that agent's stated goal to the community is to get the highest possible sales price on any particular property. I don't think way people quite get that, the whole concept of farming. So if you get a heads up and it is an agent who farms the area, point that out. Yeah.
So Brittany is on this call, and I'm so happy to see her name on here. Brittany, if you want to talk, just unmute yourself, because I would love your input on this. All right, here's a scenario that I've been thinking through. You have a listing agent who sells the property. The buyer comes without an agent. There's no agent. Historically, you would put it, if that buyer asked you to put the deal together, you were getting both sides, right? That was kind of the industry term that we would see. You're getting both sides, and you probably put your name on both sides, or your brokerage on both sides of your contract, both as the listing broker and the selling broker. In this new world, you can still do that as long as you have a buyer brokerage agreement. But there might be a workaround, even if you don't have a buyer brokerage agreement. Just don't put your name on the buyer side.
Or put none or NA.
And none, NA, leave it blank. So you would just be the listing broker in that scenario. Per your listing agreement, you earned the full commission as stated on your listing agreement, and you're not representing the buyer. You know, you're
think I like
transactional, you're not representing the buyer. Yeah.
I think I like none better because you get these agents who show up after the fact and say, I was involved with this person, or they're a friend of this person, or it's the cousin of this person. So you want to eliminate people from crawling out of the woodwork later on. You just put none or NA.
I love that.
How does that play out though,
Go ahead, Mike.
how does that play out? Let's say all of a sudden there's an inspection item that's a hole in the roof or whatever. You know they're gonna blame you, even though it says none. So how do you protect yourself from?
Yeah. So it's a good point. I've actually dealt with this a lot. There was an agent that I worked with in Atlanta. He was a commercial broker, and I thought he was really on top of it. When he was a listing agent and a buyer would come without an agent, he would say, look, you know, I don't represent you. I will, you know, I'll be the agent. I'll do everything I can, but you need to hire an attorney. Hire an attorney to represent you, your interest, doing your elections, you know, going through the contract, answering your legal questions, all of that stuff. And I'll just be the realtor. You know, I'll keep it open for you. I'll be there for inspections. I'll be there for walkthrough, but I'm going to be, you know, kind of more hands off on your side. And he put it in writing. And I thought it was great advice. One, it helped me out because it provided value that the attorney drives. And it gave me, you know, this connection with the buyer that I may not have had otherwise. But he was able to maintain his position of like, I'm the listing agent. That's what I do. But I gave the buyer good advice and told him, go hire an attorney. Get someone to represent you. I liked that. You don't have to do that. If you want the buyer to rely on you for buyer elections and inspection items and things like that, charge them.
What do you think, Christian, about using the same formula, but say, have a letter saying hire a realtor at some hourly rate?
Totally. Yeah, use that as an opportunity to say, look, you know, go use, you know, an agent in my office. Here's someone, or use someone that I'm familiar with that I really trust and adore. Use them. Or, you know, I will, you know, like you had said, Dad, some sort of broker services, limited services. Yeah. Hey, you know, for nothing, I will do these things, but for an additional fee, I'll also do these other things. Again, this is more business stuff. How much are you willing to do? But I think the big thing.
If I'm a listing agent, I don't want to be working against some other lawyer. I'd rather be working with another realtor.
And that could be a business strategy of saying we don't want a bunch of idiot lawyers in here because, you know, we're not all that great sometimes. Yeah, I agree.
Hey.
Another builder question: can a builder's new construction home that is listed in MLS put in under confidential remarks, call builder for compensation? Yes and no. That is something that's being regulated by the individual MLSs. I know Marco is basically saying, no, you're not allowed to put anything of that sort, you know, no links, no mention of compensation or concessions, like, and it's pretty extreme fines. Mike, what are the fines on Marco if you were to violate that?
$2,500 first offense, $5,000 second offense, third grand, 15,000. And the only reason I know it is I read it. I didn't get nailed.
Well, it goes right into the Mike Hughes pocket, so blame him for it. It's a big deal.
I do have two common questions I'm getting over and over, Christian, that are very short answers, I believe. So one would be, there's 1,000 pending sales out there right now. I'm getting over and over the people that have pending sales. How does this NAR settlement affect my existing pending sale? I didn't do a buyer broker agreement. Where does that leave me? Will I still get paid? That's the easy question.
Yeah, it's a good question. NAR settlement, you're still fine. You don't need a buyer brokerage agreement, but you had good advice, Mike. Take a picture, a screenshot of the MLS compensation field before that goes away.
Yeah.
You know, just to put it in your back pocket so that there's no discrepancy later. You know, we were having those discrepancies even before the NAR settlement. This would magnify the risk to an agent in this scenario.
Second question. I'm an agent. I forgot, I got an offer that was accepted, and oh my God, I forgot to get a buyer broker agreement signed. So I'm gonna do it the next day. Where's that leave me?
Talk to your broker, but I think that I think the big risk is they're not going to pay you. You know, per the NAR settlement, you're not in compliance.
Yeah.
Oh,
And
Mike,
so,
the cell number.
yeah, the buyer may be willing to pay you. You might have all your paperwork together with the buyer, but you don't have all your paperwork in relation to your broker's policies, and your broker's policies are related to the NAR settlement. You know, the buyer doesn't care about the NAR settlement. Your broker does, and you should. And so that's, you know, that's a real issue that I hope doesn't happen. And here's the advice: don't cheat. Don't backdate it. Don't change the dates. If you find yourself in that situation, talk to us, talk to the broker, talk to the buyer, you know, find something that, you know, like, all right, I'll get you on the next one. Or if you're listing a property, charge more on the listing, but don't break the rules. Don't backdate something. Don't commit fraud. That would be bad. Another question Billie Jean asked, I've talked all about these buyer brokerage agreements, but I haven't mentioned listing agreements. I'm sorry about that. There is a disclosure that NABOR drafted that you can use to update an existing listing agreement. I don't think it's out yet. Mike, and correct me if I'm wrong. I don't think it's been published, but it will be. But basically, it's nothing that a simple email can't send out. That you really don't need to change very much, if anything, in your listing agreements. You know, you might want to send an email to the sellers updating them, hey, there has been a change. You know, as you already know, commissions or compensation is negotiable and not set by law. You know, there is a change in MLS, so the agents won't actually see what the commission being offered is. If you have questions, just call me. I would say put something like that in an email, talk to your customer. That's probably it. You know, Mike, you had done something months ago where you added language into your listing agreements just to kind of make them so that you don't have to amend them later. I
Yeah,
thought
we
that was
put
pretty cool.
verbiage in there that all commissions are negotiable and not set by law. And yeah, we got the wording, put it in there because I saw that this was going to be an issue down the road, and thank God we did it.
What do you think about this, guys? The disclosures Mike talked about at the beginning of this podcast that were coming out from NAR today. You could email those to your existing listings. It
That's
gives
a
you the
possibility. I mean,
here's the
it's short and
disclosure,
sweet.
just to let you know, we're keeping you in the loop, that sort of
Keeping you
thing.
in the loop. I think the biggest thing that I would want to protect against is not only compliance with NAR settlement, but just, I don't want my seller to say, I didn't tell them. You know,
Yeah.
all this is going on and all these changes, it affects the marketability of my property and you didn't tell me, especially if it affects their pocketbook. I would just want them to know, hey, I sent you the email. I told you to call me. I gave you a call. I texted you, whatever it is. You don't want to look like you were sitting on your hands, because that's an easy way to get yelled at, sued, or even fired.
I would save the email too, confirmation that they got it.
Totally.
You know, you talk to them, put a little note on the email. And again, it's that disclosure form Mike was talking about initially in this podcast.
Someone
Which
asked me what buyer brokerage agreement do I prefer? Whatever
Only-
one the buyer will sign. Yeah, whatever one the buyer will sign, doesn't matter to me. I would say if you're used to using NABOR, if you're used to using FARBAR, just you try and make it as streamlined as possible. Don't reinvent the wheel. They're all fine. They're okay. Mary Kathy says on the buyer brokerage compensation, can you just put, 3%? Yes, you can.
Yes.
Yeah, that is allowed. If working in Lee County, can we use the FAR buyer agreement? Yes. You could use any buyer brokerage agreement. You could use one that is drafted out of, a different brokerage. You could use one that's based out of a different state. As long as your broker approves it and will get you paid, that's fine. No problem. We're just trying to be in compliance with NAR and give you a leg up with these MLS changes. Cheryl asks, I'd heard that the commission amendment had to be done before the showing occurs. Is that not correct? We don't really know, Cheryl. If your broker is saying it has to be done before the showing, you got to follow those rules. Mackenzie asked that question earlier, and my answer was, you got to use the most restrictive rule that you're subject to, because then you're in compliance with everybody. So that would be, I don't see why you couldn't amend your buyer brokerage agreement the day before closing and still get paid. I don't see why you couldn't, unless your broker won't allow it, or they're fearful that they'll get sued or have some sort of compliance issue. The broker really will matter, because I can only give legal advice. I can't make a business decision based on your license or the broker's license. And so, a lot of people will try and reach out to us asking, hey, is this allowed? And we'll say, well, we think so. Our legal opinion is yes, but you really need to go to the broker. You need to get them to approve it, because I'm not the one that pays your check. I think that's it. I don't know. I'm tired. How about you guys?
I
We
woke
will
up.
have a whole new batch of questions next week.
Yeah. So fast forward. I think we'll keep doing this. There's a lot to learn, but in a future episode, Nick Bobzian and I are going to discuss, probably August 14th, which is 2 Wednesdays from now. We're going to discuss right before the August 17th deadline, with 2 weeks of kind of background and feedback. And we're going to have a list of things that are like, all right, here are the big issues. Here are the big complaints. But here's my parting advice. Come to as many of these, or watch them online later, or talk to someone. You don't have to just watch our videos. You can read articles about it. It is somewhat of a national thing. So there's a lot of thought speakers and thinkers on this that are pretty valuable insights. I'm reading as many people as I can, just to kind of bring it all together. And then, just read every email that your broker sends, honestly.
It's going to evolve as we go. I mean, this is going to transition for.
It's going to evolve. It's going to transition. There's going to be like, policies and procedures that are being updated. There are going to be FAQs. There's going to be, brokers that are putting commissions on websites that they can refer to. I don't know what's going to work. Your broker matters the most, and understanding how their process works matters the most. So, Mike, this is your time to shine.
Well, the reality is best practices will evolve and be developed in the coming days, weeks, and months. And, a lot of people are freaked out right now just because it's changed. But the reality is, if you really drill down to what they're trying to accomplish, it's just a couple things. One, the compensation fields from the MLS are being eliminated. Two, they're going to require you to use the buyer broker agreement, and they want the buyer to have more say over his commission. I mean,
More
really,
transparency.
those three things really jump out at me.
Yeah, so we're going to do our best to comply. We're going to, try and be thoughtful, try and be considerate. But we got a lot of work, and I give you guys credit. Anyone that's watching this, you're doing the right thing by listening, reading, watching, and trying to formulate a strategy. We'll see how it works. That being said, people will still want to buy. People will still want to sell, and they're still going to want you involved. And more importantly, they're going to need you involved, because I can't do this without you. Mike, I can't do this without you. Please, let's make this happen. Guys, good luck. Call me if you need me. Thank you.